Hey guys, this is Brett from the Prosecutor's Legal Briefs. Just me today. Alice is still recovering, still enjoying her little baby boy. Thank you guys so much for all your thoughts and prayers. I know she really appreciated it. Everybody's home, everybody's healthy, everybody's doing great. So we really appreciate you guys. Just me today, which I know is a little weird, but I did want to talk a little bit about the Daniel Penny case. I know a lot of y'all have been following that. Today, as I'm recording, Daniel Penny was acquitted. And acquittals are interesting things because for good prosecutors, a not guilty verdict, it isn't something to necessarily be ashamed of. You guys know it. Juries are unpredictable, and hard cases with real victims are often worth pursuing, even if they end in a defeat. And prosecutors should decide whether to pursue a case based on the strength of the evidence and their reasoned belief that the defendant is guilty beyond a reasonable doubt. And a prosecutor who decides not to bring a case because he's afraid he's going to lose it is not a good prosecutor. Still, when a prosecution fails, there are always lessons to be learned. And boy, is that true of the Daniel Penny case in New York City. I know there are probably some of you who don't know the background of this case. I'm going to give you a brief one. There's more to learn. But Penny, he was recently acquitted in the chokehold death of a man named Jordan Neely. Neely was 30 years old. He was homeless at the time of his death, and he had a history of suffering from mental illness. According to witnesses who testified, Neely entered a New York City subway car in the midst of some sort of mental break and possibly high on synthetic marijuana. I think the prosecution actually conceded that he did have synthetic marijuana in his system at the time. And he shouted about wanting to go to prison. He shouted about how he was ready to die. He supposedly threatened riders. Some of the witnesses reported that they feared for their lives. Now, Penny was a 24-year-old Marine, and he put Neely in a chokehold, and he eventually rendered him unconscious. Now, Penny would later say that he was driven to act when Neely approached a mother and her son and told her, "I will kill." Neely subsequently died, and Penny was charged with second-degree manslaughter and criminally negligent homicide. There was a lot of things at issue in this case. One of them was whether or not Penny acted reasonably in sort of a self defense type situation. There were also questions about the cause of death for Neely. Was it really what Penny did or not? And given the close proximity between death and Penny's actions, I think we can probably say that there was a relationship there. But look, that was something that was contested at trial. I can't say. I didn't watch the whole trial. I wasn't on the jury. But one thing I can say for certain is that there was a trial and the jury deadlocked at the end of it on the second degree manslaughter charge. That was the more serious of the two. And basically, because of the way the jury instructions were written in the law in New York, you could not convict on second degree manslaughter, or you could not reach criminally negligent homicide until you had a decision on second degree manslaughter. So since they were deadlocked on that, they're essentially deadlocked on everything. The judge did what judges often do in situations like this, gave the jury an Allen charge. And this is a special charge intended to spur hung juries to a decision. But the jury remained at an impasse. Now, ordinarily, a deadlock after an Allen charge leads to a mistrial. But the prosecution here, they took the highly unusual step of asking the court to dismiss the second degree manslaughter charge and instruct the jury to continue to deliberate on the lesser offense, criminally negligent homicide. This is not something you see every day. In fact, I don't know that I've ever seen it. Maybe it's more common in some jurisdictions, but this was a weird one for me. And it's pretty obvious the prosecution believed, that by dropping the most serious charge, it would spur the jury to action and that maybe non guilty jurors would side with them. But if that was what they hoped, they were mistaken. The jury acquitted Penny on the lesser charge. And that is the end of this case. You dismiss that one count, that first count. Jeopardy had already attached. The jury was in the box. That charge is gone forever. You can't now say, well, never mind, we're going to bring it back. No, this case is over. And because he was tried, you couldn't bring other related charges. Anything that arises from this common nucleus of facts, as people often call it, is done. It's over. Penny has been acquitted. He's going to go free. Now, like with most acquittals, as I said earlier, there are lessons to be learned here for everyone involved. Arguably, and this is one of those things that would be argued strenuously, this is a case that should never have been brought. Penny, obviously, I think this has been proven, I guess, by what the jury did, had a strong defense. Neely was threatening serious bodily injury or death to others. And that's a situation in which a bystander is allowed to step in and neutralize the threat. It's actually basic common law self-defense. And in a lot of cases, I don't even think that would be contested. But this case had a racial element. Penny is white, Neely was black. And there were a number of civil rights organizations that demanded action in this case. They thought this did have a racial aspect. They thought, and perhaps they're correct about this, that if Neely had been white, the reaction would have not been as violent. It would not have led to his death. I don't know whether they're right about that or not, but it's certainly an argument that you can make, and you can understand why they made it. And look, I have no problem with the public, with groups like this, holding prosecutors accountable and demanding action when they think action is necessary, and to take cases like this seriously and to look hard at them. But that's what that means. And that's what you should be demanding, an open and honest evaluation of the evidence and of potential defenses. And the prosecutor should not bring a bad case simply because the people demand it. Mob rule, I don't care why you have it, even if it's for a good cause. It is anathema to our system, and it is a bad thing. And if prosecutors had taken a serious look at this case and decided not to pursue it, a detailed and reasoned accounting of why they took that course could have gone a long way to dousing simmering racial tensions in the city. Look, you may think this is Pollyanna of me, and maybe it is, but I'm not saying that everyone would have agreed with that. I'm not saying that if the prosecutor in New York had looked at this case and said, look, there's not a case here, the evidence isn't there, the defense is too strong, maybe even the defense is justified, this is a tragic case all the way around, but we can't say it's a criminal case. There would be people who would be angry about that. There would be people who rejected that. There would be people who would take political action because of that. But there also would be people who would listen and would say, okay, there are people who would buy that. And certainly I think it sets up a situation where at least people feel like this is not something that is purely racial. This is not something where a jury is rejecting a conviction solely because of the race of the defendant. I don't think that's what happened here, but there certainly are people who do. And if you had someone in a position, an elected prosecutor, especially, who is connected to the community, who came out and said, I've looked at this and I don't think there's a case here, I think that goes a long way. And frankly, that is one of the responsibilities of a prosecutor. One of the responsibilities of a prosecutor is to say to the public, there's not a case here. And I'm going to take the hit for that. You know, you may be mad, but I'm going to take the hit. You may be saying, well, maybe the state did perform that examination and just decided to go ahead anyway because they thought the case was there and they thought it was strong. Well, I think the problem with that argument is it is belied by their willingness to so quickly dismiss the most serious count. And that would indicate they didn't do that. I mean, there's a big difference between these two counts, between criminally negligent homicide, which is a very low-level crime, which is basically just you kind of made a mistake and somebody died and you should have known better, basically. You know, you look down at your phone for a second and run a stop sign and hit somebody and they die. I mean, that might be criminally negligent homicide. You obviously had no criminal intent. You didn't mean to do anything. Just something went horribly wrong. You did something you shouldn't have done and somebody died. Second-degree manslaughter is a lot worse. The sentence is a lot worse. 15-year sentence for that. And you would think if you took a hard look at this case and you thought that was appropriate, that you wouldn't be so quick to dismiss it, particularly in circumstances such as this. And it seems like if they did have confidence in the case before, it was pretty easily shaken. And I want to talk about that more, but I also think there is a more subtle lesson that's lurking in this case, and it's one for prosecutors around the country. Do not play games with juries. The decision to attempt to break a deadlock by dismissing a count, it smacks of jury manipulation and coercion. The prosecution shouldn't have tried it, and the judge shouldn't have allowed it. The law tries quite hard to avoid even subtly coercing or manipulating juries into reaching a verdict. In the Allen charge, we've talked about that. It's right on the line. And there are a lot of defense attorneys who make some strong arguments that it's unduly coercive, that it violates the due process rights of defendants. And think about it. If a juror, after good faith deliberations, cannot get to guilty, he can't get there, doesn't see the evidence, it's not there, can't get beyond reasonable doubt, has all sorts of reasonable doubts, doesn't an instruction that says, well, hey, that's great, but why don't you try harder? Why don't you work on that problem you got? Because, we're all waiting to hear the verdict. Can't you see how that risks coercing them into agreeing to a verdict that they don't actually believe? They don't actually believe it's beyond a reasonable doubt. It's not like the instruction gave them more evidence. It just tells them, hey, you need to make a decision. In some jurisdictions, only allow the judge to give an Allen charge once for that reason, because it's like you just keep on telling them, hey, man, make a decision, make a decision, make a decision. Eventually, the juror's going to throw up their hands and say, fine, I'll go along with what everybody else says. And a lot of courts say, look, that's just too coercive. It's beyond due process. You can't do that. And so what we have here, though, is much worse. In the Penny case, you have the prosecution on the fly dismissing a count in the face of a hung jury. And the message to the not guilty holdouts is clear. Be reasonable and compromise. Just like we're being reasonable and compromise. Look how reasonable we are. You got problems with this? We'll dismiss that. That's fine. We're working together. We're trying to reach yes. We're trying to get to yes here, right? It's almost like a negotiation. Let's compromise. Let's be reasonable. Imagine what a holdout, not guilty juror is thinking in that circumstance. Now, they've already been told by the judge that, hey, you need to work this out. Now, they've been given the Allen charge that basically specifically instructs them that you need to reach a verdict. That's sort of your job here. It's important. Hung jury is wasteful. It's bad and all this other stuff. Now, on top of that, you got the state giving up a charge that the state believed in, offering an olive branch, if you will. If the state can be reasonable, why can't you? That's essentially what they're saying. And at that point, we've sort of lost the plot, right? So we no longer have a jury working through the process, designed to test the evidence against the constitutional standard, figure out whether the state has produced evidence of guilt beyond a reasonable doubt. That's not the question anymore. That's not what we're talking about. Instead, you got the state engaged in this pressure campaign to break the will of the holdout. And preventing that kind of compromise is so important that it is written into most jury instructions, which urge jurors not to surrender their honestly held beliefs due to pressure or out of a simple desire to end the process. And that's why, some people who were surprised by this, who were sort of lay people who don't really know the score on this kind of thing. They were surprised that Penny's defense team actually opposed the prosecution's very unusual move to dismiss this charge. And they did it for this very reason, but the judge allowed it to happen anyway. But in this case, it backfired. The deadlock was broken, but it resulted in an acquittal. And this was surprising. I think it surprised most people. I think most people, when they heard that very quickly after this happened, the next day of deliberations, actually, there was a verdict, they thought, well, it worked. They're going to be guilty. They're going to get to guilty. I mean, obviously, at least one juror believed Penny was guilty of the more serious charge. If that weren't true, they would have acquitted. And yet, with that charge dismissed, You got the jury turning around and they're quickly reaching a verdict of not guilty. But why? Why did that happen? And so quickly. Now, we can't know, of course, unless the jurors tell us, and they may do that in the days to come. But there seem to be two possibilities to me, at least. And if there are more that you guys can think of, I'd love to hear them. The first is that the jurors themselves recognized the attempt to manipulate them and they sort of acted accordingly. This was almost like a jury nullification thing where, oh, you're going to do that? Well, I'm not going to be a part of that, and I'm going to vote to acquit. And in my mind, that's entirely appropriate. Jurors and juries, as we've said before, they are a bulwark against tyranny. That is one of the roles of juries. That's one of the reasons we have them. Yes, they find facts, but they're also protecting our rights. So if they did that here, I have no problem with it. But the second option, which I think might actually be more likely, is that the state's move was disheartening and it was coercive, but not the way the state thought it would be. If you think about it, you think about most cases, you think about what do defense attorneys say. Defense attorneys will often say things like it only takes one. And the idea is we only need to convince one juror. And if we can convince one juror, we can get a mistrial, we get a hung jury. Maybe we get a better deal afterwards. Maybe the state decides not even to prosecute. Worst case, we get another bite at the apple, right? And the thinking there is ordinarily holdouts tend to be one or two or three or four. Really probably doesn't get beyond that, but it can be evenly divided. But usually one or two not guilty jurors. That's what we've got. Got a couple people, got 10 guys and gals who want to convict, and we got two people who are saying, no, it's not guilty, I'm not going to do it. And already outnumbered, without much hope of convincing their fellow jurors to acquit. They're hearing the Allen charge, they're seeing this dismissal, and they're susceptible to the kind of coercion that I think the state intended here. But in this case, it appears that actually the holdouts were guilty voters, however many of them there were. And what did they see? They saw a prosecution who was unwilling to stand by the charges before them. And they may simply have lost heart. If the state thought their case was weak, shouldn't the jury feel the same way? Isn't this almost reasonable doubt in of itself? The fact that the state is saying, hey, we don't even know about this prosecution. We're so unsure of this. We're willing to dismiss the main count, the one that we've been arguing this entire time. It's not hard to see why a jury would logically conclude there's a problem here. And if that was the reaction of the jury, they were entirely right. And I think it reveals something, frankly, that's rotten at the heart of this prosecution. We had two men's lives that were at stake here. One was Jordan Neely, and behind him was a family and a community who was eager for justice that the state, through its actions, had signaled could only be accomplished through a second-degree manslaughter conviction. They are telling everyone this is what should happen here. That's why we're bringing this charge. We believe in this case. We believe the evidence says this. This man committed second-degree manslaughter, and we're going to try and convict him. And who was that other man? It's Daniel Penny. He's facing up to 15 years in prison because the state exercised its solemn obligation to determine that justice demanded a conviction for second-degree manslaughter. And yet, with the case not even over, the prosecution dropped the charge. Now, look, I totally get it. Conserving prosecutorial resources, it has to be consideration after a mistrial is declared. But after is the key here. That's when that decision is ordinarily made. It comes after some circumspection, some thinking, some talking amongst the lawyers, talking with their bosses, talking with the police officers investigated, consulting with the victim or their family, with the added information of just how many jurors didn't buy the state's theory. For all we knew, there was one not guilty holdout on the most serious charge, the charge that the state told us was necessary for justice. And yet, they decided to drop that charge. And no matter what, if they hadn't done that, they could always decide to try again with a new jury. No matter what they found out. Even if they found out that there was only one guilty person. If they believed in the charge, and maybe they thought they could beef up their evidence some, they could have gone again. But not now. Here, the state, on the fly, blows up the process. To get a conviction, any conviction, The state dismissed their most serious charge without even knowing the final vote count. They did so even though they knew that this charge could never be brought again. As I said earlier, jeopardy had attached. This case is over. And you got to ask yourself, if the state truly believed that Penny was guilty of second-degree manslaughter, why would it do this? If justice demanded it, why not at least consider trying the case again with a new jury and perhaps a new strategy? And look, if they had done that, the state could always decide later to only pursue a lesser charge in a new trial. They always could have done that. And perhaps with a focus on that charge, the lesser charge, but nevertheless fully focused on that, maybe they avoid a future deadlock. Maybe they get justice for their victim. Instead, they threw away that chance. And they got nothing in return for it. Nothing but an acquittal. And I think that the state's decision smacks of a desire just to get a win, any win, whether it was for political gain or out of pure hubris and pride. They just wanted to get some sort of win. It wasn't about justice. It wasn't about what justice required. That was no longer the primary consideration. And I think if that's true, and I think it is, the state failed in many ways. And losing the case was the very least of them. It failed Daniel Penny, who was branded a murderer and was forced to endure a lengthy process before his name was cleared. It failed Jordan Neely, who, depending on who you ask, has alternatively been held up as either sort of an innocent angel, the guy who was, he was a Michael Jackson impersonator. He just wanted to live his life, and then demonized by others as this incredibly violent person who was a threat to everyone, and had all these issues. While the lost truth, the real truth, is that Neely suffered from mental illness, and that mental illness and his struggles were basically ignored by society, that left him out there on the street with no help to fend for himself until the inevitable occurred, the inevitable that occurs for so many people in his circumstance. And the state also failed the community. They reinforced this idea with these charges that this was a criminal act, that it was in fact a racist attack that demanded the harshest justice that they could manage. And then at the last minute, they pulled the rug out from underneath them. What does that say to them? What does that say to the community about whether or not they can trust the justice system or they can trust the prosecutors? If you think the prosecution coming out and the state coming out and saying there's not enough evidence here, we don't have a case here, or the defense is too strong, if you think that would have undermined their faith in the system, what does this do? What does handling it like this do? And look, people are going to continue to debate this case, and we've barely scratched the surface of the facts. I'm sure people have a lot of opinions. I'm sure people on both sides are going to come and offer those opinions and offer all the evidence about why I'm generally wrong or specifically wrong about certain things, and that's fine. Go ahead. These kind of cases get debated. But I think there is one thing that should not be debated, and that's that the state of New York and the prosecutors in this office failed across the board. And frankly, someone should be held to account for it. I don't know that will happen. Don't have a whole lot of faith that it'll happen, but it should. Love to hear your guys' thoughts on this case. Like I said, I know this one's divisive. Y'all handle these cases so well. Your discussions are always so respectful. I hope that you'll do that here. I really think that most people want to get to justice. I truly believe that. Like I said, maybe I'm a Pollyanna, but that's what I think. Shoot us an email, prosecutorspod@gmail.com with your thoughts, @prosecutorspod for all your social media. Love to hear from you guys. Consider joining our Patreon. You'll get these episodes early and ad-free. And if you do want to discuss this case, head over to the gallery on Facebook. I'm sure there are great discussions going on even as we speak. Well, thank you so much for joining for these quick thoughts on this case. And we will be back next week. But until then, I'm Brett. Don't have Alice here today, but maybe she'll be back soon. And this is the prosecutor's legal briefs.